warm welcome to the fourth lesson out of our 50-part series on the law of evidence. In this video and the next couple of videos, we will be talking about the very important concepts of relevancy, admissibility, and appreciation. In today's video, we will talk about relevancy. In a very simplistic way, if we were to see what happens in a trial, you have a judge who decides what these two parties who are pointing a finger at each other have to say, and on the basis of the material that is placed before him, he arrives at a decision. So essentially, this party would be saying something for the judge to hear, and then this party says something for the judge to hear. He hears both of these, and on the basis of this, a decision is arrived at. Now, in doing this, there are two possible approaches. The first approach is that you take all the material at hand and decide, which means that the judge listens to everything that this party has to say, So he's heard him fully, he's heard him out fully, and on the basis of that, he decides as to which one is heavier. So he then decides on the basis of that as to which one is heavier. That's one approach. The second approach is that he decides not to listen to everything. So he puts a bit of a screen, right? He does not allow everything to reach. So let us say there are 4 things that have been said. He only allows 1 to reach. Let us say this person has said 5 things. He only accepts 2 of these things. He's selective in the material that he inspects. It's important to see that these are 2 different approaches. In the first case, you listen to all the material and decide. In the second case, you are selective even in the material that you inspect. Now, both of these approaches have their pluses and minuses, right? As far as the first approach is concerned, I'd like you to have a look at this video by clicking the I button. You can have a look at that later on, where I've discussed this idea of trying to find the truth by looking at all the material. But for the time being, in this video, we will focus more on the second approach, where the judge is selective in the material that he inspects. Now, what is the purpose of the Indian Evidence Act, or the law of evidence in general? You see, the consequence of facts as to who has the right, who has the liability, all of this is the province of substantive law. It is not what procedural law deals with. Evidence is a procedural law, and the objective of the Act is simple. The objective of the Act is to permit only that kind of material to reach the judge, which has probative and logical value. Think of it like this. Numerous things are said to the judge from both sides, right? Now, the purpose of the law of evidence is to act as a filter, right? It acts as a filter in between. You can think of this as the law of evidence. What this does is that it will permit only those things which have logical and probative value to reach the judge. Which means that if something is irrelevant, which means it is illogical, let's say it's irrelevant, or if it's illogical, or if it is unreliable, the law of evidence prevents this from reaching the judge. This is the objective of the law of evidence. Now, you might ask a very legitimate question. Why do you want to choose? Why do you want to be picky? Why not listen to everything and then arrive at a decision? Isn't that the best way to do things? Well, your point is not without merit. However, we must remember that this is a law of procedure, and the law of procedure is based on certain principles and has to serve certain purposes. For example, the trial needs to be speedy, and therefore it is expeditious for not all the material to be considered. The law already decides, the law of evidence already decides that there are certain pieces of material which, if considered, will enable justice to be delivered fast. Therefore, speed is one of the objectives because of which not all material is accepted. Second, it's a matter of plain convenience. You see, again, procedure is meant to facilitate the smooth functioning and dispensation of substantive justice. So it becomes convenient for us to not have to listen to everything. That also is the purpose of procedural law. And like I said, perhaps listening to everything is not even practicable. A trial needs to end, and if all material is started to be considered, then perhaps we might not even see the end of a trial. And therefore, I can pretty much say that it is convenience and practicability and speed which is the reason for which not all evidence is accepted. Otherwise, in an ideal world where there was no paucity of time and when everything was possible, then perhaps it would have been wiser for all the material to have been considered. But given the practical constraints of our reality, it becomes more prudent to not accept all the material and be selective instead. What the law of evidence does is it tells you as to how to be wise in selection. So it gives you guidelines on what to select and what to reject. Like I said a little while ago, what does the law of evidence do? The law of evidence is not about determining the consequences of facts, because that is something which is done by substantive law. Right? So let us say A slaps B. It's a fact. Now, what happens if A slaps B? Does A go to prison or does A get a reward? Well, that is something that substantive law deals with. So the consequences of facts is not something that the law of evidence is concerned with. Instead, it deals with establishing those facts, which means, suppose you have a fact, A slaps B. Did A really slap B? Or did A not slap B? This needs to be established, and the law of evidence basically concerns itself with this. That when you have a fact, to ascertain whether that fact actually happened or did not happen, to establish its existence or non-existence. This is the purpose of the evidence, of the law of evidence and the Indian Evidence Act, of course. We've discussed the difference between these already in the previous video. We have seen that what the law of evidence essentially does is that while there is a lot of evidence waiting from both sides to reach the judge, the Evidence Act or the law of evidence sits here as a filter in between and only permits some of the material to reach the judge, right? So now the moot question is, what is the kind of evidence that is permitted and what is the kind of evidence that is rejected? To explain this to you in one line, the kind of evidence that is permitted is that which discloses relevant and disputed facts. Think of it like this. You see, every piece of evidence carries a fact. You see, evidence, whether it's in the form of a witness or a document, whatever it is, every form of evidence basically has a fact. Okay? Now, this fact could be of various kinds. Either it could be disputed or it could be something which is agreed upon by both the parties. Now, if it is a fact that is agreed upon by both parties, in that case there is no need for evidence. So if it is agreed upon, there is no dispute as far as that fact is concerned, then we do not need evidence. Okay? The second thing is that the fact that we are talking about could be either relevant or it could be irrelevant, which means it is unconnected to the matter at hand. So if something is irrelevant, again, we don't want to see evidence for such a fact. So if the fact is irrelevant, we don't want the evidence, which basically means that we need to have evidence relating to disputed as well as relevant facts. This is what essentially the test is. If there's a disputed fact that is relevant, evidence can be given for it. Otherwise, the court refuses to even peruse such evidence. We've just seen that it is required that the fact be both relevant and disputed for evidence to be permitted. Let's take an example of a case where the fact is relevant but not disputed. Obviously, in such a case, evidence will not be taken. So let's take an example of one such case. Let us say there is A is an accused, and obviously on the other side you have the public prosecutor. Let us say A has been charged with murder. Okay. Now let's say there's a certain fact. The fact is that, let us say this is the trial for the murder of B. Now let us say that on the night that B was murdered, A was at the same place. Right? So let's say if B was killed in a certain place, then A was at the same place. Now, is this fact relevant? Obviously, it is relevant. But let us say the public prosecutor says that A was at the same place. And what A says is, yes, I was at the same place, but I did not kill him. Now, is there any disagreement as far as this fact is concerned that A was at the same place? No. There's a dispute because A says I was present but I did not kill. But as far as this particular fact is concerned, it is relevant, but there is no dispute, and therefore evidence is not required for such a fact. Moving on to the other kind of example. So we take the same example again where A has been charged for the murder of B, right? And on the other side, of course, you have the public prosecutor. Now, let us say the public prosecutor says that Kareena Kapoor is A's favorite actress. Okay? And A denies it. He says, no, the public prosecutor is wrong. My favorite actress is Alia Bhatt. Now, this clearly is a dispute, right? It has been said by one, denied by the other, but this fact is not relevant, and therefore the court does not want to look at any evidence for who the favorite actress of A is because it is disputed, but it is not relevant. So again, in this case, evidence will not be seen. So what we've understood is that it is a twin test that has to be satisfied as far as facts are concerned. First, the fact should be relevant. Second, it has to be in dispute, which basically means it has been alleged by one and denied by the other, right? If this is not so, it means it is a fact which has been admitted. And facts which are admitted do not need evidence, whether in civil or in criminal. Facts admitted need not be proved. We've been talking about relevancy for a while now, as something which deals with two facts being connected. Now, is this connection a matter of logic, or is it something which is determined by the law? In other words, is it about logical relevancy or about legal relevancy? Let me give you a little example. Let us say there's a person who is now lying dead here in a pool of blood, all right? And there is this person who is seen to be running away from this place. Okay, now let us say there's this person here. Okay, he doesn't see the murder happen, but he sees this person running away, and this person has a blood-stained knife in his hand. And then he goes and sees that this person is dead. Now there are two facts here. The first fact is, let us say this person is A and this person is B. Let us say the fact number one is that A killed B. First fact. Second fact, A was running away from the place where B was killed. Right? Now, as you can see, this person is a witness to only the second fact and not the first. Now the question basically is, do we want to consider the second fact? Is this second fact relevant? If you think of your own logic, then perhaps you would say yes, it is relevant, which means it is logically relevant. But is it also legally relevant? Well, for that we need to look at the law, which basically means, does the law declare this thing to be relevant in some way? If yes, it is also legally relevant. So that essentially is the difference between logical relevancy and legal relevancy. The difference being that sometimes what appears logical to you may not be in the law, and what is in the law as relevant may sometimes not be logical to you. But that's what the purpose of the law is. The purpose of the law is to give some amount of definite character to things, to remove the subjectivity of different minds, to bring about some uniformity. So therefore you can think of legal relevancy as being legal principles which determine as to what is relevant, and ultimately legal relevancy is what prevails over logical relevancy. So let us say your logic says something is relevant, but the law says it is not. then what will prevail is legal relevancy. If the question, therefore, is whether relevancy is a matter of law or logic, well, it is a matter of both because law is not without logic. However, only those rules of logic which have also been accepted by the law by means of codification constitute the rules of relevancy, which basically means that let us say there is something that you feel is logically relevant. You feel that it is logical, and the law also feels that it is logical, which means that it is codified, which means it will find itself in section whatever of the Indian Evidence Act, for example. If that happens, okay, good, it is a matter of logical relevancy as well as legal relevancy. But suppose you feel something is logical, but the law feels that it is not logical, which means that it has no legal relevancy, then you can perhaps say that it is logically relevant but not legally relevant. So you kind of get the idea of this entire discussion. So something which appeals to your logic or appeals to the logic of the reasonable man is what is logical relevancy, and what has been finally decided by the law is legal relevancy, and what prevails is that legal relevancy prevails over logical relevancy. So as far as the legal relevancy of facts is concerned, which obviously involves some amount of logic, so legal relevancy also involves logical relevancy, in the context of the Indian Evidence Act is given almost entirely between the sections 5 to 55 or perhaps 6 to 55. So you have fundamentally two kinds of sections in here. There are some sections which will tell you that some things are relevant. So it will say that section 6 says something is relevant, section 7 says something is relevant, section 8 says something is relevant. So these tell you that some things are relevant. On the other hand, you have the kinds of sections that say that something is not relevant, this is not relevant, this is not relevant. Let's say, for example, section 24 says that something is not relevant, 25 says that something is not relevant, 26 says that something is not relevant, and so on. So you basically have these two categories of sections in the Indian Evidence Act which tell you as to what legal relevancy is. And on the basis of this, you can pretty much decide whether any given fact is relevant or not. Now let me ask you a little question. Perhaps this might have even cropped up in your head if you were paying attention. We just saw that between the sections 6 to 55, there are some sections that say that, okay, this is permitted, this is permitted, this is permitted, this is relevant. And there are some other sections which say that, okay, this is not relevant, this is not relevant, this is not relevant. Now, there is a third category of facts, if you might appreciate, the ones that have nothing spoken of, in the sense that the Evidence Act neither says that they're relevant, nor does it say it's not relevant. They're just not mentioned. Are such facts relevant or not relevant? Answer that in the comment section. The question basically is that the Indian Evidence Act says that some facts are relevant, like I said, section 6, 7, 8, 9, these say that some facts are relevant. Likewise, you know that 24, 25, 26, they talk of some things which are not relevant. So these are two categories of facts for which the Indian Evidence Act speaks loudly. However, there are some facts for which nothing is spoken of. Are such facts to be considered relevant or not relevant? What do you think? Let me know. When we talk of relevancy, it basically deals with one question, which is that what can be given and what cannot be given to the judge. It deals with the question of what. Remember this? We'd seen in the beginning of the video that we would be talking about relevancy, admissibility, and appreciation. Now, once we've decided as to what has to be given and what should not be given, now what has to be given also has to be given in a certain manner, and that is determined by the question of admissibility. How do you give what has to be given? Is there a manner that is prescribed for it? That is what is addressed in the question of admissibility. How? And once you have decided what has to be given and how it has to be given, and then it is placed before the judge, then the judge decides the reliability of that evidence after it has been given to him. And this decision making is what is known as the appreciation of evidence. In the following two videos, we will discuss admissibility and appreciation in some detail. By the end of those videos, you would have an idea of what happens to evidence in the court. I hope this lesson made sense to you, and thank you for your patience. Good day.